Good morning, good afternoon, and good evening to all of you who are on our call today. Welcome. I'm Ann Massey Badmus, and welcome to our National Interest Waiver Green Cards webinar for the month of October. Before we get started, I want to be sure that everyone do a sound check. So anyone who can hear me, please put yes in the chat feature of the platform. Great. Thank you so much. I appreciate that. Got a lot of yeses. All right. So again, welcome. And as we proceed, I want to be sure that you all know that you can ask questions at any time during this presentation. So to do that, be sure to use your Q&A section. It should be at the right of your screen or somewhere if you're listening on your phone or iPad or tablet, you should be able to see a icon with a question mark on it, and that is where you should try to submit any questions that you have. That's just an easier way for us to keep track of the questions and be sure that we answer them. So along the way, if a question comes up as I present information, feel free to add your question to that Q&A portion of or Q&A section of the platform. But we do ask regarding questions that for confidentiality, please ask your questions in a general manner. Try to refrain from any personal details. This is an open platform, so we want to be sure that your confidentiality is maintained. So try to keep your questions, first of all, brief, and also keep any personal details out of your question as well. Okay, so just a little bit about our firm and myself, who is presenting this presentation today. For those of you who do not know us, we are Badmus Associates. We've helped thousands of clients with immigration status since 1993. We've received some recognitions as best lawyers in Dallas for immigration by D Magazine, as well as best lawyers list for immigration nationwide, and best law firms for the Dallas-Fort Worth area. So that just gives you a little bit of background on us. So next, I do want to be sure that you understand that the content that we're providing in this presentation is for informational purposes. Please do not take it as legal advice because everybody's situation is different, especially when we're talking about things like national interest waiver, where there's just a lot of variables involved. So please be sure not to use this information as legal advice or be relied upon as such. For your own specific case or your matter, it is wise to reach out to an immigration attorney with our firm so that we can help you tailor your application to meet the requirements. So that being said, let's move on to our agenda because we have a lot to cover today. First, we're going to talk about or give an overview of what we call the visa numbers for employment-based green cards. It's very important to know, particularly because of timing. It's because many of you who are of course interested in this type of process or in any type of green card process need to know about the timing of that. And so an overview of the immigrant visa numbers will give you some idea of the timing that you might find when dealing with national interest waivers or in other green card applications as well. But then we'll go more in depth into the national interest waiver green card and its requirements. There are actually two different types of national interest waivers. The majority of our time will be spent on what we call the national interest waiver general, which means generally for any occupation, and then we'll briefly touch upon a specific national interest waiver that is only for practicing physicians in the United States. And then next we'll do just a general green card application process overview, and then have time, we hope, for questions as you send your questions along the way. So again, if you have questions, make sure that you put in or you try to use the Q&A feature so that we can answer your questions. So this little cartoon is basically telling you that, getting a green card in the United States is not a straightforward path. It can be pretty much a legal maze. And so what we're trying to do here today is to give you some information so that you can potentially have permanent residence if you can get through this maze that we can help you with. So as I mentioned, we want to talk about the visa numbers. So it's important to know about visa numbers, again, because there is a limited number of green cards available every year in both the family-related applications, where a family member is a U.S. citizen or a permanent resident family member is sponsoring one of their qualified relatives. But there's also an annual quota or limit to the number of employment-based green cards that are issued each year. So this graphic here, or this chart, talks about the EB, which is employment-based green card annual quotas. So starting this month in October, there has been a new number of visas available. Typically, there's about 140,000 visas available, or green. When I say visas, I mean green cards or immigrant visas, which is equivalent to a green card or permanent residence. So the EB green card annual quotas are kind of broken down into these different categories. As you see here, the EB1 category, which is what is called the priority workers, made up of different types of applications. That's 40,000. So those are taken up first. They're given priority. And then if there's any left over, it filters down to the EB2 category, which we'll talk about today regarding national interest waiver, because national interest waiver is a EB2 category. So then we have, after that, the EB3, which is professionals and other workers, typically going through what's called the PERM process, which is employer-sponsored type of process. And then we have EB4, special immigrants, which is for those who are typically religious workers. And then there, I don't have on this graphic, but there's the EB5 category for those who are immigrant investors. So why is that important? As I mentioned, the timing of the process, whether you're EB1, 2, 3, or 4, really depends on these visa numbers. So every month, the government, specifically the Department of State, issues what's called a visa bulletin, which kind of gives us an idea of when either we can submit an application for the last step of the process, which is called adjustment of status. If you're in the United States, it's called adjustment of status. That's the very last step of any green card process. It tells us when we can file that application for adjustment of status. And it also tells us when we can expect to, or whether there is an actual immigrant visa green card available for our application even after we have filed for adjustment of status. So what I have depicted here is the visa bulletin for this coming month, November 2023. And it's just to try to briefly go through, the way that this is set up, or the way that to make it meaningful for you. This is what we call the dates for filing chart. So this is the chart that currently the USCIS, which is the agency that accepts adjustment of status applications or processes adjustment of status applications. This is the chart they are using to determine whether or not you, if you're an applicant, can actually submit your adjustment of status application, which again is the last step of the process. So here, it is showing for the EB2. I'll just focus on the EB2 category. The EB2 category is this section here, second, as stated on the chart. It is saying that the cutoff dates, these are cutoff dates, these various dates that you see here are called cutoff dates. The cutoff date for EB2 is January 1st, 2023 for everyone who is born anywhere except India, China, India, Mexico, or Philippines. So if you're born in one of those 4 countries, you would look under those specific columns. But if you're not born there, then you would look under the what they call rest of the world or all chargeability area. And as you can see, what they're saying for that area is January 1st, 2023 for those who submitted their first application before January 1st, 2023, or the first step of their application process, are now able to apply for adjustment of status. So right now it's about a 9-month waiting list, but that can change every month. There's a new visa bulletin and it tells us what that cutoff date is. And sometimes it moves forward, sometimes it stays the same, and sometimes it even goes backwards. So this is something that you would want, if you're in the process, would want to know about and check every month to see where you fall in line with the visa bulletin. So you can find the visa bulletin, at least the adjustment of status charts, from the uscis.gov visa bulletin info, the website that I have here. And so when you file, let's say if you do apply for national interest waiver, when you file your first application, which is called I-140 application, you will be given a priority date. The priority date is based on the date that you actually filed your application, your I-140. So if you filed your application today, October 19th, 2023, your priority date would be October 19th, 2023. And that's the date you need to compare against these cutoff dates on this chart. So next, you also want to know that even though you might be eligible to file your adjustment of status application, you also have to consider what's called the final action chart, which determines when the government can actually approve your green card application after that it has done all of its typical processing. So after it's done the processing, done background checks, reviewed your application, the government now has to look at this final action chart in the month that they are processing your application. So for example, if they are processing your I-485 application in November of 2023, they have to look at your priority date. And again, your priority date is the date that you filed your I-140, your first application. So if your priority date is October 19th, 2023, but the chart says for EB2 category that the cutoff date is July 15th, 2022, as it does here, that means even though they've done all of their processing, they have to hold your application and cannot approve it until the cutoff date is after your priority date. And in this case, per the example, it would be after October 19th, 2023. The cutoff date has to be after October 19th, 2023 in order for them to finally approve. So this means that the green card process, whether it's EB2 in particular that we're focusing on today, can take, could take years. But like I said, it fluctuates depending on every month that the visa bulletin is issued. So it can stay the same or it can move forward. So this is something that you really need to watch. So the website I have listed here on this slide is related to the related to the Department of State visa bulletin. So this is where you would check monthly to see whether or not your priority date is eligible for final action, meaning final approval of your green card application. All right, so that being said, let's talk specifically about national interest waiver green cards. As I mentioned earlier, there are two types. We're mainly going to focus on the general national interest waiver green cards, which applies to any occupation. And then lastly, we'll briefly discuss the national interest waiver green card that applies only to practicing licensed physicians in the United States. So what are the advantages to the EB2 national interest waiver before we talk about the specifics? Well, one big advantage is this is one of the very few green card applications that does not require sponsorship. This is an application where you can, what we call self-petition, meaning that you can file on your own. So you do not need to have the approval or sponsorship from any U.S. employer in order to submit an application, as long as you can prove the other qualifications. So that kind of relates to the second advantage, which is a specific job offer is not required. So you do not even have to have a potential employer or a U.S. employer that has offered you a position in your field of expertise. This is a really big advantage because most other processes, such as the PERM labor certification, as mentioned as this third bullet point, the PERM labor certification process is a process that does require an employer sponsorship, and that employer has to show that they simply cannot find U.S. workers in the labor market for your occupation. It is a very protracted process, which can take, currently it goes through the Department of Labor, and it can take over a year or so just to get through that first phase of the process. So the national interest waiver, actually the waiver is the waiver of the PERM process. So the United States in providing this kind of green card path is saying that if you can prove that your work in the U.S. would benefit the United States, be in its national interest, then we're not going to require you to have an employer. We're not going to require you to have a job offer. And we're not going to require, of course, an employer to prove that it cannot find U.S. Workers for your occupation. So that waiver is a huge waiver, but you have to counterbalance that by showing how you're going to benefit the national interest, which we'll talk about more detail in a few minutes. And then the last, the other benefit is the less strict eligibility as compared to EB-1A, which is the EB-1A extraordinary ability green card path. That requires that you show a minimum of 3 out of 10, special skill criteria with very strong proof of that. There's a lot of subjectivity in that process. There is some also in the NIW green card, but the NIW green card is typically easier to approve and are easier to qualify for. So as a result, the approval rates for the NIW green cards are usually higher than the EB-1A green card applications. Another benefit, there are a few other benefits that also, these are benefits that could apply to any category, but it's important to know that because you can get into the EB-2 national interest waiver category a little faster than you could if you went through an employer-sponsored PERM process, it could be a real advantage, especially if you are at the very end, near the very end of your H-1B 6-year limit. So if you're in the US and you have an H-1B and you've almost used all of your 6 years on the H-1B, then having an NIW I-140 approval can be used to extend your H-1B beyond the 6 years. Actually, you can extend indefinitely until almost indefinitely until you're able to actually apply for adjustment of status. And this can be particularly important for everybody, but for those who have longer waiting times because you're born in India or China, for example, this can be an advantage, of course, because it will take longer for you to actually get into the adjustment of status or be approved for the green card. So having the NIW approval can be used to continue extending your H-1B until you're able to finally get your green card. It's also beneficial for those who have spouses on H-4 that want to work. So having an NIW approval can be used to support an H-4 EAD for your spouse. And then also, even if you decide that you want to go a different path, and maybe even a faster path to getting the green card, like an EB-1A category, if you've established an earlier priority date through the national interest waiver, that priority date can be transferred to your future application, which could be an EB-1 application, or if you were employer sponsored later for whatever reason, that priority date is still there. So once you file one I-140 application, you establish your priority date, and there's nothing that restricts you from filing another green card application if you so qualify. That potentially could be faster or give you a different path if you no longer want it to be on the NIW path to the green card. So that being said, what are the requirements for national interest waiver? I kind of broke these down into about 4 different requirements. The very first one is that the applicant, if you're applying, needs to be either a member of the professions holding an advanced degree, and we'll talk about what that means in a minute, or you can be a foreign national of exceptional ability in science, arts, or business. Oftentimes we get people who are looking at NIW, and it gets a little confusing because they're thinking, well, do I have to show exceptional ability? And they talk about exceptional ability as if that's the only criteria. However, oftentimes you don't need to be concerned with exceptional ability if you are a member of the professions. It's an easier way to qualify for this first part of the national interest waiver by showing that you're a member of professions rather than going the path of exceptional ability. But in some cases, you may not be a member of the professions holding that advanced degree. So therefore, the exceptional ability route is the route that you have to go in order to qualify for this first part of the national interest waiver requirement. So what does member of professions holding an advanced degree means? Well, the member of the professions, when you think of professions, probably comes to mind things like doctors, lawyers, accountants, things like that. But the list is actually quite extensive. It covers pretty much almost any occupation that typically requires at least a 4-year college degree, bachelor's degree. So this is the website where you would go to find out what is considered a member of the professions, or a typical list of member of professions is actually generated by the Department of Labor, where they are saying these are the occupations that we consider professional level because they typically require at least a bachelor's degree or higher to qualify. So that being said, if your occupation, your field of expertise is on that list is considered a member of the professions. And the next question to ask is, do you have an advanced degree? So an advanced degree to the US means either a master's degree or higher, or a bachelor's degree plus 5 years of experience in your field of expertise. So if you have a master's degree, which is either from the US or considered equivalent to a US master's degree, and you're a member of the professions as stated on that list, then you would qualify as an advanced degree professional. If you don't have a master's degree, but you have an equivalent of a bachelor's degree, or a bachelor's degree, US bachelor's degree, or a foreign equivalent. Now, when we say equivalent, we mean an actual college degree, not experience-based. So if you have a college degree from another university or college in a different country, and an evaluation is done to show that degree is equivalent to a bachelor's degree in the US, then that's the first step. And then next, we need to look at whether you have at least 5 years of progressive experience related to that bachelor's degree. So for example, if you're an engineer with a bachelor's degree, to qualify for it as an advanced degree person, you would need to show that you have a bachelor's degree in engineering, and you also have at least 5 years of working as an engineer in your field of expertise. So that's the very first step that's needed to prove that you are a member of the professions, and that you have an advanced degree. If you do not qualify based on that, if you do not hold an advanced degree, then we have to look at, can you qualify as an exceptional ability professional or exceptional ability person in the sciences, arts, or business? So you can see it's a pretty broad range of occupations that come under sciences, arts, or business. So there's really not much of a limit there as far as the types of fields that would be considered. But in order for you to actually qualify as exceptional ability in that particular area of expertise, you have to show at least 3 or meet at least 3 of the following criteria. You can show that maybe you do have, maybe not necessarily, you could have a bachelor's degree, but not enough experience to qualify for the advanced degree professional. However, or you may have other kinds of degrees, associate's degree, a diploma, a certificate, some other kind of educational certificate from a college or university. Then that could be one criteria. Another criteria is that you have shown at least 10 years of full-time experience in your occupation. And that would be evidenced by letters or verification letters from your current or former employers. If you are in a profession that requires a license, then if you have a license to practice that particular profession, that's another criteria they look at. Fourth criteria is if you have a high salary, or some other compensation that's been really high compared to others, that's another factor. If you have been have membership in some professional associations related to your field. And then the last 2 is showing that you have accomplished or been recognized for achievements or significant contributions, as evidenced by by government entities, professional organizations. And then finally, there's other comparable evidence, which is sort of a bucket of, prove how you think whatever evidence you have goes to show that your exceptional ability. So again, we won't go much further into this point, but essentially you would need to meet at least 3 or provide evidence of at least 3, if not more, of these types of evidence in order to qualify as exceptional ability in the sciences, arts, or business. So if you're able to meet that requirement, then we still need to go and consider the second requirement for a national interest waiver. And that is that the proposed endeavor, which is the work that you will be engaged in the United States, has both substantial merit and national importance. So that, is a pretty broad term, but basically what you have to show is that your work will be, it has a purpose. It has a real, could have a real impact. For example, if you're in healthcare, the work or healthcare research as an example, well, that's certainly a substantial merit because of course there's interest in healthcare. Healthcare is a big factor, a big consideration for the US. And so if you are going to be working in a field where you are going to provide services in healthcare, that could be a field of substantial merit. That's just an example. There are many other examples, and we'll talk a little bit more about that. Then you have to show specifically for yourself how your work moves that endeavor along. So going back to the healthcare research example, if you are working on a cure for cancer, just very broad, but you're working on a cure for a particular type of cancer, you would need to show that you're working on that particular project along with anyone else who's working with you is important to move that along. If your work is not high of a level, like for example, if you are a technician on that particular project, a lab technician, that might not necessarily be considered to the point where your work is absolutely necessary. You specifically, your work is absolutely necessary for that, especially if they can find a lab technician to do that same work. So it has to be something that will require some sort of uniqueness on your part, some special skills, or something that will show that you specifically are very important to moving this endeavor along. And then finally, how is this work important to the United States? What is the national importance to the United States? So some examples of that would be of national interest or national importance would be, in some way your work would improve the U.S. economy. It could improve or help with wage conditions of workers, create jobs, improve education and training, improve healthcare, medical research, increase access to energy resources. So for example, if you're in clean energy or oil and gas or something like that, that could be another benefit. Now, again, these are national interests. If your work is so narrow in that it is only really going to be related for your specific employer's benefit, but not necessarily have any reach farther than that, then it may not be considered national interest. So this is something that we have to show that there will be some reach beyond just your employer's benefit or your own company's benefit or your own personal benefit in working in the U.S. Some other examples would be providing affordable housing, improving the environment. If you have a request from a government agency where they are interested in what you're doing and they're able to provide the support by usually providing a supporting letter or you can show other documentation then of their interest in your work, that would be a really strong indicator of national interest. And then this is relatively new. In 2021, the Biden administration announced that, progress in STEM fields and the role of people with advanced STEM degrees, like a master's or higher, could be, another national interest. Now, a lot of times because of that announcement, it's been a little misinterpreted to mean that if you have an advanced degree, then that's all you need. It's not the case. You need more than that. Again, you still have to show that the work that you'll be doing has that national reach. So having an advanced degree is a positive because there is a national interest in having more STEM professionals in the U.S. But you also have to show that what you're working on, for example, maybe a critical or emerging technology, or some other areas that might be important to the U.S. competitiveness or national security. So those of you who are in tech fields or in STEM fields, you can always check the this link that I have on the slide. That kind of is what the government has considered to be critical or emerging technology. So if you're working in those kinds of areas, you could have a better chance of getting approval for a national interest waiver. But again, it's not limiting. I mean, there could be other areas as well. But that is really one of the focuses of the national interest waiver, is those who are in the STEM fields. So next, going to the third category, which is our third requirement, is a national interest waiver. So now that if you've established that you have the advanced degree or your exceptional ability, and then you also show that the work you're doing has national importance, next you have to show how you are in particular well positioned to advance this national importance endeavor. Some of the factors they're going to look at is what is your education, your skills, the knowledge that you have that you bring to the table to this particular endeavor, what your record of success has been. So for example, if you were working on, I don't want to say only research because it doesn't have to do only with research, but if you have been involved in certain projects that are related to what you're doing now and they've been successful, that will be a big consideration. If you haven't done that, but perhaps you're not even in the U.S. and you haven't been working in the U.S., but you have a model or a plan that you can show that if this model or plan is activated and you're allowed to work towards that end, this could have, you would be a person that would be able to move this endeavor forward. If you have interest from other people, such as customers, investors, for self-employed, for example, not self-employed, entrepreneurs, for example, if you have investors, especially U.S. investors, interested in your proposed work, in your technology or projects and things like that, that would also be a factor to show that you are well positioned to advance. So some of the evidence to provide to show that you're well positioned would be, of course, things like your degrees, your certificates, or licensing. If you have had patents, trademarks, or copyrights, that would be helpful. Letters, what we say recommendation letters, are important as well, not only to describe your past achievements, but also talk about how that project would need your expertise. If you've written articles or had articles written about you, that could be helpful as well. If you have a plan describing how you plan, you could provide a plan describing how you plan to continue the work in the United States, or you can have a business plan as well to talk about or show how you will be able to, for example, start up a business or start up a business in order to implement the kinds of projects that you're trying to do. So a detailed business plan can help in that regard if you are not already working in that field in the United States. Some other examples would be letters. Examples of evidence would be letters from potential employers, clients, customers. If you have, again, received investment from U.S. investors, such as venture capital firms, angel investors, of course, you should have proof of that you did receive those investments. There, copies of any contracts, agreements, or licenses showing that there's a desire or need for the work that you're going to be doing. Letters from the government agencies, if you were fortunate to have a government agency that's interested in what you're doing, it's particularly helpful. And if you've received grants, or the projects that you've received grants, but you specifically being part of that project or designated as either a principal or important member of that project, if that project has received grants from federal, state, and local government entities, that's another evidence of that. So finally, the fourth category, our fourth requirement, again, is the national interest waiver. For the national interest waiver is, it looks a little odd, but it's basically saying that even if you prove all those things, you also need to show that it's more beneficial for the national interest for you to be involved in the work that or project that you are proposing, rather than requiring your employer to go through a labor certification process. If you recall, I mentioned earlier that the national interest waiver waives the typical perm labor certification process where an employer is sponsoring a U.S. Or sponsoring a potential employee to work for that company. The U.S. has a big interest in being sure that if a foreign worker is being hired by a U.S. company, that foreign worker is not displacing a U.S. worker. So that is the purpose of a labor certification. So that's a big interest of the United States. For them to give up that interest, they need to know why that interest is lesser than the national interest that you will provide the other national interests. So, for example, if you're going to provide national interest in healthcare, why is that national interest greater than the labor certification national interest? So so these are some examples of how to prove that. For example, it could be the labor certification just isn't practical, isn't possible because you don't have an employer. You're an entrepreneur. You don't need an employer. So that's not going to make sense for you to do a labor certification to prove that there's someone to take your place as an entrepreneur and owner of a company. So that doesn't make sense. But even if you are directly employed by an employer who doesn't want to do a labor certification, or you don't want to do a labor certification, you can show that even if there are people who might be minimally qualified to do the job that you do, the United States is going to be better off by having you working in this field because maybe of special skills that you have that can't be captured by the labor certification. Or if there's an urgent need, like having STEM field professionals in the United States, that could be another factor. And that's something we often use if you do have STEM background, to show that yes, it's urgent for the United States to have more STEM professionals. So that's more important than trying to do a labor certification test. And then another example would be that the job or the endeavor that you're going to engage in could actually boost the economy or create substantial jobs, which is going to be much more beneficial than doing a labor certification. Okay, so I know we have a lot of questions and we're going to get to them in a minute. I think we're in good time to do that. So that concludes the part about the general national interest waiver. Again, to summarize, it covers pretty much any type of occupation. And if you can prove the different requirements that we just went over. I will briefly talk about the physician national interest waiver in case there are physicians here who are interested in that. So the physician national interest waiver basic requirements is that the applicant has a medical degree, of course, is licensed in the state that they're planning to work. But the key requirements are that you are agreeing to work full-time, which means 40 hours a week, in a designated health professional shortage area, medically underserved area, or a VA facility, Veterans Affairs facility. If you are committed to doing that or willing to commit to do that, at least for the part of this application, does not mean you cannot later go through a different route to get your green card, but to apply for the physician national interest waiver, you do need to show that you have that commitment. And typically that would be the commitment of showing you're going to work for 5 years in an underserved area. And to prove that, you would either need to have a contract or contracts that cover that 5-year period. Or if you're planning to be self-employed, some people will use what's called a self-employed affidavit. Or if they are already self-employed, they can have a contract with their own company to do that. But it's important to note that regardless of when you apply, your green card will only be issued after you have completed all 5 years. And of course, if your priority date is eligible for issuance of a green card. So if you start out, in the beginning of your 5-year contract and you apply for national interest waiver, you will initially be approved if you meet all the requirements. But for the government to actually issue your green card, you will have to have completed all 5 years. So depending on when you start the physician national interest waiver, it could take it at 5 years or more to actually get the green card. And then the last thing that I want to cover briefly is that you do need to have a letter of support from either a federal or state agency that is agreeing that your work in that underserved area is in the national interest. Okay, so lastly, we just want to cover briefly the green card procedure overview, because I think there are some questions that we're getting here about the process and the procedure. So it's pretty much a two-step process if we're talking about going through the national interest waiver. If you're going through a PERM process, you're talking about a three-step process. So that's another benefit of the national interest waiver is you don't have to do that PERM process. So it's an actual two-step process as opposed to a three-step process. So the first step for the national interest waiver, of course, is the I-140 petition. So of course, you want to be sure that you meet or feel comfortable that you could meet the criteria for the national interest waiver, the criteria we just went over. So you want to have a review of your background and get if a professional opinion, I would recommend, as whether or not you would qualify or potentially qualify for national interest waiver. If you decide to proceed, you want to make sure that you collect extensive evidence, not just your degree. You need to provide a lot of evidence showing how your work benefits the United States and is in the national interest. So that could be a pretty can seem overwhelming, but it does, it's worthwhile if you can provide a lot of evidence. The stronger the evidence is, the more evidence you have, the stronger your case will be. This national interest waiver is still a little subjective. So the officer does have a lot of discretion to determine whether or not your evidence in their minds meets the national interest requirements. Once you have all that evidence, you file the application, the I-140 application to the USCIS. The regular processing time can be variable. It can be a few months, it could be 6 months, it can be a year. If you want to have a guaranteed processing time, then what you would do is pay for the $2,500 premium processing fee, which guarantees 45-day processing. It's a little different than the other premium processing, where it's usually 15 days. For the national interest waiver, it's a 45-day guaranteed processing, although we have seen them do it a lot faster than 45 days, but that is their guarantee. Once that, if you are approved for the I-140, you are approved that from I-140, then that means that they are saying, yes, we believe you qualify for the green card based on the national interest waiver. You can go to the next step to finally get your green card if you meet other criteria, such as a visa number is available. That means if your priority date is eligible, you can now file your adjustment of status. In some cases, you may have to wait a few months to do that, or it could be a year or two to do that. So it really just depends on what the visa numbers are looking like at the time that you get your approval and what your priority date is. So if you're in the United States and you have legal status, then you can apply for adjustment of status. If you are outside the US, then the alternate is that you would attend an immigrant visa interview at the US Embassy in your country. And we'll talk a little bit more about that in a second. So the next thing is for adjustment of status. As I mentioned, you need to be in legal status, legal non-immigrant or valid non-immigrant status, and have no status violations in order to apply for adjustment of status based on NIW. Now I say no status violations for more than 180 days. So we're not advocating that anybody violate their non-immigrant status for any period of time, but there is a special rule that says that if you are currently, for example, an H-1B status, and maybe there were some issues in your status, like maybe you worked without authorization for a month or two, that can be forgiven. But if you worked without authorization for 6 months, more than 6 months, then they're not going to allow you to do adjustment of status. So there's a lot of variables there, but you have to be careful to be sure that you are eligible for adjustment of status by showing that you are in valid status and no serious violations for more than 180 days. Your I-485 application can be filed, you as the principal applicant, and then any family members that qualify, which would be family members which are spouse and children under the age of 21, typically can qualify to file adjustment of status. And then with the adjustment of status, that is where you get things like the EAD and the advanced parole travel permission. Now, these are temporary benefits. They are just for you to be able to work and travel while your I-485 application is pending. If for some miracle that you get your I-485 approved, your green card approved before you even get this EAD or advanced parole, then they're going to not issue those documents, which is fine because you don't need them. They're just temporarily there for you while you're waiting for your green card. But typical processing time, depending on your country of birth, again, for the adjustment of status, can be anywhere from 12 or 36 months, or it could be more. So these are all just general numbers. There's no guarantee by the government, so I certainly cannot guarantee any time frame as well. And then the last thing we'll talk about before questions is the immigrant visa process. So that's the alternative to adjustment of status, and that might happen for people if they are not in the U.S. in legal status. So they are outside the U.S., but they've been approved for national interest waiver, so you have to go through the immigrant visa process at the embassy. Or if you have certain violations or you're not able to do adjustment of status for whatever reason, might be a process, you might be eligible to do the immigrant visa process outside the United States, as I described here. This process is also dependent upon your priority date. So if your priority date is, especially if you're like from India and your priority date is going to be 10 years off, you're not going to go through the immigrant visa process within 12 to 24 months, as I stated here, because you're going to have to wait till your priority date is current before the embassy will even consider to process your application, because just like the USCIS, the Department of State, the embassy cannot issue a green card to anyone unless their priority date is eligible for that green card. Okay, so now we'll go to questions. Quite a few. Many of them are in the chat, so I'd appreciate it if you put your question in the chat, if you can cut and paste and put it into the Q&A section. I will try to come back to that if necessary, but the chat part is very difficult to navigate. It's much easier if you put your question into the Q&A section here. So the first question I have in the Q&A section is, do I need to continue doing do I need to continue doing research and or publishing papers after getting my I-140 approved? I won't say absolutely, but it is a good idea, because if you are not in the I-485 stage yet, or even if you are in the I-485 stage, sometimes the government does request to know, are you still working in your field of national interest in the area that you said you'd be working in? Because they're not going to approve your final green card unless they're comfortable that you indeed are going to work in the area of national interest that you stated in your I-140 petition. So unless you have another way of getting the green card, I would suggest to continue to work in that field. It doesn't necessarily have to be with the same employer, but if you have for example, if you are working in medical research in a specific area and you decide to move to a different medical research, if you can tie those two together, or, you should not have an issue. But if you were going to do medical research and then all of a sudden you stop doing medical research, and then before you get your green card, and now you're going to do clinical medicine and not do any research, that's going to be a totally different thing. They're not going to consider that to be in the they're not going to consider that to be the basis for your application. So it's important to determine before you move on to any other type of position or career, whether or not that, would be considered part of the national interest there. Okay, so the next question is publication a critical requirement? Is it the only way to get NIW approved? And the answer is no, it's not a critical requirement depending on your occupation. Sometimes, if you are in research, it probably is a critical requirement. If you are not in research, you were doing something different, it's helpful. Let's say if you're in industry, working in IT and working on some technology that's going to be a game changer. Well, it may not be necessary for you to have a publication for that. If you have it, it could be helpful. So it really just depends on your occupation. Okay. Next question is, how could physicians get it? Do we need a sponsor? Is it better than H-1B? There's a lot of questions there. We'll try to answer that in one. So physicians can apply either national interest waiver that I discussed. They can do the general if you're doing things like research or something that is different than clinical practice. You do not need a sponsor because NIW is a self-sponsored application. And it's not necessarily, well, it's better than H-1B in that it is a green card. But you do have to be mindful of maintaining legal status up until the time that you can actually apply for adjustment of status, which is that last step that second and last step that I discussed. Only with adjustment of status are you allowed, or do you have legal status based upon that green card process. So if you have an I-140 approved, that does not affect your status in the United States. It just means that you have sort of a ticket to get in line to get your green card eventually, but it does not affect your status. So you have to still have an H-1B or whatever the type of visa you have if you want to remain in the United States until you get to the second step. And in many cases, we recommend you keep that H-1B or if you can, even while you're waiting for the green card. So you want to try to maintain that up until the time. You don't have to, but it's a safeguard to keep that H-1B up until the time you actually receive your green card. Next question, any expectation about whether the next month visa bulletin will move forward? We actually showed the next month visa bulletin, which is November 2023. So that's already out. I don't know yet about December. I usually do not like to talk about what to expect because it's just really beyond, it's really out beyond prediction. Even the government has a difficult time predicting it. So we just have to look at it when it comes out. But right now it does not seem to be much movement. There's been some because October started the new fiscal year, but it hasn't moved as rapidly as it has in the past. So that's not optimistic, but that's essentially what we're seeing right now. Question is, can we get a recording? Yes, we have a recording. So everyone who's on the call will receive a recording. You just check your email to be sure to look for that. It'll also be on YouTube on our YouTube channel. For the general NIW, do we need to apply for this before leaving the U.S. or can it be applied for outside the U.S.? So I'll answer that one first. You can apply whether you're in the U.S. or outside the U.S. So the initial application, the I-140, again, has no impact on your status. So whether you're in the U.S. or outside the U.S., you can apply for the I-140. But it's important to note you do need to show how your work, if you're outside the U.S. in particular, how your work is going, how you can work how you will be able to work in the U.S. and that work will have that national importance. Another part of that question is, can J1 with home residence requirement apply for this? Yes. And when would it be better to apply for a J1 visa, just before leaving or after serving the 2-year home requirement? Well, it depends on where, I would say just based on the priority date, if you can apply before, because what you want to do is to at least get your priority date established as early as possible. We are seeing for all countries, there is a waiting list developing. I don't know how that's going to get, if it's going to get better or not. It could get worse. So the earlier you apply, the earlier you get in line. If you wait after the 2-year home residency requirement, then you're already 2 years behind. So you want to be sure that you at least get. So once you get your I-140, it does not expire. So if you're not able to, finish your process until later, because of whatever personal situation, such as doing the home residence requirement, the I-140 is still going to be valid. So if you can apply, I would suggest to apply regardless of what you might need to do later before you can finish the process. Next question, can I-140 be used to support L1A extension beyond the normal 7-year limitation? So yes, I mean, it did, any I-140 can do that. So yes, that would be the case. Okay. Do you have any evaluation for EB1? Can I send my resume? Yes, we do. We will send out by email how you can schedule a time to evaluate your CV. Okay. Another question, member of professions, do you need to be registered with the professional body like engineers board? So no, not necessarily. So if you're, for example, for engineers, I know that engineers, you can be considered an engineer without being a professional engineer registered by a board. So no, you do not need to have that. Most people are not having that kind of board registration. So in that case, you know, if you're talking about engineering, I would say it's not required as long as you have either the master's degree or higher in engineering or a bachelor's plus 5 years of experience, regardless of licensing or registration. Can I use I-140 to extend work authorization from OPT? An I-140 is not a work authorization document. It does not do anything to extend your OPT or give you a work authorization. There is a very special what's called I-140 EAD, which is rarely used, and you really have to show extreme extenuating circumstances as to why you cannot remain, for example, in H-1B status or F-1 status. So it's possible, but it's very discretionary. So I cannot say that that's something that you can easily obtain just by having an I-140 approval. Due to the hard work of acquiring recommendation letters, is it viable to use the NIW letters for EB1 in case of meeting the requirements? It's possible you can use NIW letters. The phrasing is a little bit different. It just really depends on the content of the letters, but it is possible. Another question, can you apply for an I-485 on a B1, B2? The short answer is yes. If your I-485 has not expired, if your I-485 has not, if your visitor stay, that meaning that your I-94, because you're in the United States, you receive an I-94, which has an expiration date. If your I-94 has not expired or has not been more than 6 months since your I-94 expired, then it's possible to do an I-485, but it can be a little tricky because of the visa bulletin and the priority dates and the timing of when you actually can even apply. For EB2, you probably, if you came into the US on a visitor visa and you were very close to your priority date being eligible for I-485, then that might work. But it's you would really have to monitor the timing of that, your visitor expiration, and the timing of when you can actually apply for adjustment of status or the I-485. What if I've already, another question, I think this is related to the physician NIW, is what if I have already worked 5 years in a designated HPSA? If you have already worked for 5 years, then yes, that time can count. If you can get the documentation and the supporting letter from the state or federal agency, then you can, and actually that will mean that if they approve you for the NIW based on your past 5 years of work, you are no longer obligated to work in a underserved area, or no longer obligated to continue working in an underserved area. You can work anywhere pursuant to an H-1B, or if you are able to apply for adjustment of status, you might be able to get an EAD. But essentially, once you've done the 5 years in the health professional shortage area, you are eligible for NIW, and you're also not required to continue working in that type of area. Next question, when can H4 dependent apply for an EAD? Can it be done after the approval or have to wait until after adjustment? Also, is it different for PERM versus NIW? So the answer to the last question is not different for PERM or NIW. It doesn't matter. If you have an approved I-140 on any basis, then your H-4 dependent spouse can apply for the EAD. They do not have to wait for adjustment of status because there's a different EAD related to adjustment of status. The H-4 EAD is related to the fact that you as the H-1B worker has an approved I-140. I'll take a few more questions, or just, I think I'm just going to stay in the Q&A section because we're running out of time, and I think that's all the questions that we can answer at this point. Can I begin the process of the NIW right now as an H-1B holder? If yes, will this affect H-4? The answer is yes, you can begin the process of NIW. Applying for NIW or any green card process is not affected by your, or does not affect your status or the status of your dependents. The first phase of the process, the I-140, has no determination on your status. Like I said, you can be outside the U.S. and apply for I-140. You can be in the U.S. and apply for an I-140 NIW. So that really has no impact on your status, or there's no requirement that you have any particular status in order to apply for the I-140. I work in a battery field, but not necessarily publication. I would like to rely on my publications for PhD, but still mention my current work. Okay, that is very specific. I would need to consult with you specifically on that to really determine how we can, make that work for you. So I would suggest you contact us for a consultation so we can specifically address those types of questions. But thank you. Do I need an attorney to file an N-400? Okay, so I can't really speak on charges about charge. The other question is, what's the average attorney charge? I cannot speak about other people's, other attorneys' average charge. If you are interested in working with us, feel free to contact us about the N-400, which is a citizenship application. But I will say that, no, it's not. There's no requirement to have an attorney to apply for any application. Depending on your circumstances, it might be helpful to have an attorney for a citizenship application, but in many cases, many people do not need an attorney to do that. Questions: will slides be shared, or how can we get access to the links referenced? So yes, the slides will be shared, so you will get those. Thank you. Someone wants to book a meeting. Well, thank you very much. We will be sending out the information, but you can always also go to our website if you want to book a meeting, www.badmuslaw.com. Where you can actually fill out a short form and request the information to book a meeting. Thank you. Next, I have a bachelor's degree in engineering, but now I work in marketing. Again, we would, for that kind of specific question, we would need to schedule a consultation so that we can specifically address your background to see how that would work. Finally, if we filed I-140 with dependents information, how can we get our dependents abroad to join us? So I'll answer that very briefly. That if you have dependents who are not in the U.S. and cannot do adjustment of status, when your I-140 is approved and when they are eligible for getting the immigrant visa outside the U.S. at the embassy, you will need to file a specific form in the U.S. to request that the embassy be notified to set up the appointment for them. If we get an approved I-140, this is our last question, can one travel to the U.S. on a B1, B2 and file for adjustment of status after the 90-day rule? It's possible. I cannot commit to that. I would definitely need to speak with you definitely to see if that would be a good option for you. But generally you can, if you have a B1, B2, having an approved I-140 does not void your B1, B2. So you can certainly do that, travel, and we could potentially look at whether it's a good idea to apply for adjustment of status after that. Okay, so thank you all very much. Again, you'll receive a recording and the slides after this presentation. If you need assistance, feel free to reach out to us at immigration@badmuslaw.com or go to our website and just fill out our short form, and we will be out to, we will reach out to you soon after. Okay, well, thank you all very much for attending our webinar, and we wish you all a wonderful day.